The Utah courts have now released a transcript of a hearing in the Tyler Robinson case. The hearing took place back in October, but it was a closed hearing. Tyler Robinson is accused of killing Charlie Kirk. There's been some debate about media access to these hearings. I know that the defense says that it could, create a content tornado, I think is what they said. That would cause prejudice to a jury pool. And right now, it seems like media access is going to be something dealt with on a case-by-case basis. The judge has said that he's having to weigh, constitutional rights versus the public's right of access. This is a case that obviously has a lot of public interest. Charlie Kirk was killed in a very public way. There's a lot of discourse online about who people think did it, what they think happened, and sometimes that's been pretty extreme and hostile. So just disclosing this here, I'm not really going to get into the Candace Owens, Erica Kirk, TPUSA stuff. I just want to look at what's being argued in court here and how that went down and what was said by the attorneys. I'm not really here to tell you whether or not I think he did it at this point. I just want to talk about, like I said, what was going on in court that day. And remember, that was back in October, so some stuff has happened since then. But I thought there was some interesting points in here. So Tyler Robinson's attorneys asked that he be permitted to appear in civilian clothing and without restraints at all hearings. At the time, he was having to appear in jail clothes and shackles. They also said they intended to file a motion to completely eliminate all video and audio broadcasting or delayed feeds of the court proceedings. Mr. Robinson and his defense team are very concerned that the nature, content, scope, pervasiveness of the pretrial publicity, the statements that have already been made by law enforcement officers, by lawyers, by the representatives of the state in this case, may have a significant impact on the fairness of his trial. They also mention here they're going to file a motion to disqualify the Utah County attorneys from representing the state in the prosecution of the case. That's because a family member of one of the attorneys was actually present when Charlie was shot and killed. But it says they were within 85 feet of Mr. Kirk when he was killed, had to flee, that the Utah County Attorney's Office was all advised of this, that law enforcement were actually deployed to the area with her safety and status in mind. So Tyler's defense team is saying that this is a conflict of interest, and they're trying to move the entire Utah County Attorney's Office to be removed from the case. So this motion is supposed to be heard, I think, January 16th. That's a couple weeks from now. Tyler's attorneys gave 3 reasons why they think he has a constitutional right not to be shackled in pretrial proceedings. 1, they said there's a presumption of innocence. 2nd, he has a right to actively participate in his defense in the courtroom. And the 3rd reason they give is they say what the high court referred to as dignity and decorum in the courtroom. They say for the public, because most of the hearings in the case will be public, for the public to see him shackled the feet, the waist, the hands, that kind of offends the dignity and decorum of the courtroom. They're saying that the court has to make an individualized determination as to whether or not the current policy is appropriate in this case. If Mr. Robinson demonstrated, which he has not, some inability to control his conduct while in custody or while in the courtroom, that would be information that the court should take into consideration. I think the court could look at a rap sheet or a pretrial services report and say this person has a history of assaulting law enforcement or fleeing or obstructing justice, whatever it is, but none of that exists here. They say the state has offered no specific evidence that he presents a risk to anybody or to himself by being unshackled in the courtroom. And here's where they start to mention some of the conspiracy stuff that's been going on online. And remember, this is Tyler's attorney talking. So he says, now in the state's opposition to our motion, there's a lot of information, and I'll try not to be sarcastic, but I do think it's kind of noise about the intense public interest in this case. There's a reference to, unstable people coming to the courthouse, to conspiracy theorists saying things online. We're all aware of that. I mean, I don't know what the court has read. It's none of my business. I've received some wacky phone calls and emails, people telling me what they think happened here. It's noise. We're not litigating this case in the press. We're not talking to crazies. But that's all on the outside. So we appreciate that the sheriff's department is concerned with the safety of the court and all of the participants. We were here a few weeks ago, and it was clear that the sheriff's department took the first appearance of counsel very seriously, and we appreciate that. And there is some redaction here. So we don't think that the intense public interest, which may be drawing in unstable fringe people from the left and the right and the center and other places, is imputed to Mr. Robinson. The question is, can the court trust Mr. Robinson to sit there the way he has been doing for the last hour and respect the decorum and the dignity of the courtroom just like the court would expect him to? And we think that the answer is obviously yes. And I did skip down a couple pages here. Like I said, I'm not going to read this word for word. I just kind of highlighted some of the interesting points. Here it says, while we understand there's a lot of what I would call noise, there's noise on the outside, and then there is a redaction here. Like, there's not much redaction in this document compared to some other stuff that I've seen, but this little part is redacted. Maybe not. I saw one person with a camera in the lobby today. I don't know. We also got here at 2 o'clock, so maybe there was more, or maybe nobody was interested because it was going to be a sealed hearing. But none of that affects Mr. Robinson's right to be free from shackling in the courtroom absent this individualized showing. As long as this court permits cameras, whether it's video or still cameras, to broadcast either live or with delay proceedings in this courtroom, we also believe that Mr. Robinson should be dressed roughly like everybody else because the entire world has already seen him, because the sheriff's department released a booking photo, and because there were cameras in the first remote appearance in this case, has already seen him in a jail jumpsuit with a vest on. But if he's going to be in this courtroom and we're going to have a secure courtroom, but it's going to be broadcast to the world, he should not be depicted as a jail inmate. He should be depicted as a citizen of the United States with a presumption of innocence. Unless we're going to shut down all the video and all photography of what goes on in this courtroom, he shouldn't be wearing jail stripes. So the judge did ultimately say that he could appear in street clothes, like regular plain clothes, but there's also the issue of shackles, which they continue to talk about a little bit more here. So now the state is talking. It says, I think the issue raises two primary issues. The first one being, is defendant's presence necessary at a hearing? And then the second being, when it is necessary, what security measures are necessary because of his presence? And I think, of course, the overarching question involved in this motion is how best to protect the defendant's presumption of innocence and avoid tainting the jury pool while maintaining the security of everyone involved. And let me make it clear that the state is just as concerned about a fair trial in this case as the defendant is. We are going to try this case once. I think this court can resolve many of those concerns by holding non-critical hearings either virtually or hybrid with the defendant appearing from the jail. Defendant says that shackling him somehow impairs his ability to consult with counsel, but I think just like today, if the defendant has the ability to be able to make a note to counsel, I don't see how, if the sheriff believes that those requirements are necessary, those restraints are necessary, how that could possibly interfere with his ability to participate in his defense and to consult with his counsel. So Tyler's defense says that he needs to be able to make notes and participate. The state here is saying, I don't see how the shackles, prohibit him from doing that, especially because as they're sitting there, they made it so that he's able to take a note with one of his hands, you know what I mean, and make a note to his counsel. The judge asks, what prejudice is there if Mr. Robinson appears in civilian clothing to the state or to security? The state here says that if anything happens while Tyler is in civilian clothing, then it's harder to identify him and be able to neutralize a threat or protect him. He says we're talking about hearings that will not be sealed, where there will be members of the public, potentially members of the media. This courtroom will be full with many more participants, and the issue will be having to identify a defendant in that setting, not just in a setting like this. So this was a closed hearing. So here the judge is asking another question about, the prejudice, the potential prejudice issue with the jury. So even if video or photos were banned, what stops a journalist from saying, Mr. Robinson appeared in jail clothing? Doesn't that create the same risk as a video? The state says, I think your honor's order could stop that. And the judge asked to suppress a journalist from writing. The state says, I think from writing about a particular topic, just like your honor can protect jury members' identities, prevent the press or anyone from identifying a juror, you could also say there's to be no comments, no pictures, no videos about what the defendant's appearance. I mean, this was my first thought when I read that is good luck enforcing that, because people could just go tell each other, word of mouth what was happening, and then somebody who heard from somebody can blog about it. You know what I mean? That's going to go around all over the place. I'm not really sure that that's possible. So the state says if there's not going to be anything broadcast about his appearance or communicated to the public, then why not just have him appear in jail clothes? Because it's not going to prejudice anyone in the court, any decision maker, any potential juror. The judge says, but even if I were to go down that route and say a blanket order that journalists, members of the press cannot comment about his clothing, every member of the public could be a blogger. Does that extend to them? The state says, your honor controls what happens in this courtroom, and I think your honor could say there's to be no comment about the defendant's appearance. Like I said, I don't know how enforceable that is. And then Mr. Van Noy, who's with the sheriff, says, I think there's a different effect based off what they provided from seeing Tyler as opposed to a reporter writing about what he's wearing. And the judge here is saying, going back to the clothing, assuming he orders no videos and no cameras, and he goes further and tells the press not to write about clothing, even if that extends to the weekend blogger or influencer or anyone, do not write about it. What stops prejudice to potential jurors? Because this is an open courtroom. What stops anyone? 75 people is what we've limited this courtroom for security reasons. From them talking to others and saying, I was in court, he was wearing jail clothing. Does that prejudice the potential jury pool? Going back to the argument about some of the hearings being able to take place virtually, Tyler's attorney says this is a capital case and he wants to be present at every hearing in person. Mr. Robinson is not going to waive his appearance for hearings in order to eliminate the need for him to assert his right not to be shackled. That's not a voluntary waiver. Mr. Robinson wants to be in court in person so that Your Honor and he are in the same room, so that he knows what's going on, so that you can fully observe him, so that he can fully observe witnesses. So it's not an accommodation that interests us respectfully. And then one of the other points that I didn't read this, but I remember it from earlier, that the state made was that during the charged shooting, he was alleged to have changed clothes before and or after that happened. So the defense for Tyler here is saying the idea that because Mr. Robinson maybe changed clothes before or after the charged shooting has nothing to do with whether Mr. Robinson's sitting there in a sweater and blue jeans or whatever the sheriff and Mr. Robinson's counsel agree is appropriate clothing could somehow turn into Superman, by spinning around in a circle. It's just not going to happen. And I don't really understand that argument, because on the day of the shooting, he's alleged to have changed clothes before and after. I think people in the courtroom would probably notice if he had an extra pair of clothes sitting there or something like that. It would be a really hard thing to maneuver if he were going to somehow escape the courtroom, change clothes, and then get out of the courthouse somehow without anyone seeing or being picked up on camera or anything like that. I didn't really understand that argument. So I didn't think that was a great argument, but that's just me. I don't know. And that has nothing to do with whether or not he did it, right? I'm just talking about their arguments over the shackling. Tyler's attorney also here brings up the suggestion that this court can order the entire world not to say anything about what Mr. Robinson is wearing in court is both impractical. I think it's a prior restraint, and the burden would fall on us to enforce it. That's asked with a question mark at the end. It's completely unenforceable. So he's basically saying the defense would have to be the ones to enforce it. You can't really enforce telling everyone in the world not to say anything about what he's wearing. So the defense is saying the idea of prohibiting cameras and video is very easy for the court to enforce. That's easier. Like I said earlier, I'm personally a fan of cameras in courtrooms for transparency, but I'm just going over what they're arguing here. The state is saying, as far as attending the hearings goes, that Tyler would be entitled to be present with his counsel during the kinds of proceedings that are critical to the outcome of his case. But in other hearings, he doesn't need to be in the courtroom, and he can still be present, but virtually, where he can communicate in real time and confidentially if necessary. So going back to the motion to disqualify because of the family member who was present at the shooting, they're saying they want to protect the privacy of the family member, and they're requesting that this be filed privately so it's not a public document. And then one of the other people speaks up here and says, I definitely don't want the family member getting the emails that I'm getting right now. So we're going to try to protect that innocent family member from experiencing that. So they're definitely getting some crazy emails all around. Ultimately, like I said, the judge decided he could wear regular clothes, but he did decide that Tyler still had to be restrained. As far as media access goes, things are still kind of case by case, but I just wanted to go over some of the interesting things that came out of that transcript. So let me know what you guys think, and I'll see you guys soon.